Mr. Speaker, it's an unfortunate fact for society and for the negative team. The crime is highly correlated with people who are poor and unemployed. Lower socioeconomic status is a massive correlation with your likelihood to commit crime, as high if not higher than your previous offending. We see areas that are economically depressed, that have poor education opportunities, have poor upward mobility, are overwhelmingly more likely to commit crime. And that was the reality in which we wanted to minimise the likelihood in which vulnerable people were put into that dynamic and minimise the obstructions to upward mobility for people attempting to reform themselves. Whereas that side of the house refused to engage with the reality that having a job, a livelihood, the respect and the social networking that comes from that is essential to having a life that you feel is worth not living as a criminal. So 3 questions in this debate. Firstly, should employers be allowed to discriminate like this? Secondly, is past criminality a sufficient indicator of risk to allow discrimination? And thirdly, what's the impact on minorities? So firstly, should employers be allowed to discriminate? And I can see here are Paul's notes from his preceding speech that our biggest area of non-responsiveness is the burden of rehabilitation landing on employers, which correlates to where my material starts. In actual fact, it starts with a point that's been made by Gemma and Madeline, so perhaps they should have been listening more carefully. When you have a unique ability to rehabilitate somebody, when you are the only person who can offer a job, the dignity, the reliability, the networks that come from having an employment, that obligation should rest with the individual able to deploy that. Because the state shouldn't and couldn't give all criminals a job. It could not overcome that unique form of discrimination, that unique form of burdensome oppression that comes from not having employment, not having the ability to earn your own wage. So when it is true that the state is not able to redress that problem, employers, the ones who are empowered to give you a job, should have that responsibility to overcome that burden. In the same way as we recognise why the state shouldn't just give welfare to people who are disabled, it should require employers to facilitate access to employment of those people. These people have a unique form of self-inflicted disability that we think we need to overcome in society's interests and their own interests. They have an obligation to society, they have an obligation to themselves to minimise the likelihood that criminals re-offend. They are a member of that community, they should have that obligation placed on them in exchange for the ability and the right to be an employer and enjoy all of the privileges that come from operating an effective business in an area in which criminals are likely to be rehabilitated effectively. We heard that you don't need a job in order to be rehabilitated. They said lots of people don't have jobs. I've already pointed out that there's an overwhelming correlation between those people and people who are otherwise economically disempowered and committing crimes, for all of the reasons Gemma brought you about the lack of social networks and support within that community. And it's not just about whether or not you can eat, Mr. Speaker. It's about whether or not you have access to a meaningful job that allows you working conditions that suit your ability to exist in life. And then they said there are other reasons not to offend. And that's what we told you right from the start. That the decision about whether or not you offend or re-offend is a complex and competing matrix of choices. There's the social stigma on one hand, there's the likelihood of getting caught, there's the magnitude of the punishment, all of those things play in. And if we could understand exactly why people committed crimes, we would have stopped that a long time ago. The reality is, the information we do have is that when people don't have the support and are treated like criminals and are ostracised from society and stigmatised and unable to form the types of things that keep you and I from not committing crimes, that's when they're most likely to engage in that behaviour. And then they said, well, if that were true, then rehabilitation couldn't ever work, because people have this overwhelming tendency to commit crimes, it is said. We need the support networks, we need that protection. We would taking away the barriers to being able to re-enter society effectively and be treated like somebody who wasn't a criminal. But they are ultimately okay with allowing continuing punishment. And we were as well, when it was handed down by the courts.
Yeah.
Gemma and Madeline said that the person who should determine the length of your sentences are the courts, and is the state. And they should hand that down because they have the best information, they have the best ability to predict, and they are the ones that are trusted by society to do it. Because those courts require the confidence that they are the ones doing the sentencing when they assess how harsh or how lenient their sentence should be. Because if they can't predict what other sentences and what other consequences are going to be ascribed to those people by other actors, they can't with confidence ascribe the appropriate sentence. High unemployment means that you're not going to have access to this job. And in a competition between somebody who has a criminal history and someone who doesn't, employers are going to choose those who don't, even if that's not a sensible decision. And in actual fact, that decision will harm their society and harm them and their families. It was a choice we weren't prepared to empower them to do when they have that unique ability to prevent that recidivism. But is the risk high enough? There are two principles to remember before I go through this analysis. They had to show it was a high and useful correlation. You didn't have to ever say that they had a burden to show that they would absolutely re-offend. But for that correlation to be useful and helpful in society, they had to show it was one where the decision-making calculus or that presumption would benefit the likelihood of minimising crime. They also had to show that there was a risk of a workplace crime, or a crime within that environment, because it is not the responsibility of employers to try and police the entire activities of that person. They have no legitimate interest in stopping that person from committing a crime, or otherwise presuming that they might commit a crime outside of the workplace. The only interest is for those people who will commit a high likelihood and a high probability and have a useful correlation of doing something while they're at work. They said that previous violation of social norms shows that you have a poor moral code. We said crimes are overwhelmingly mistakes and errors with a huge range of mitigating factors. And we sentence those people according to those factors, and we ascribe them a punishment in the court according to the seriousness of that crime. Why do you want to take that role away from the best arbiter of that decision and put it in the hands of people who are biased and drummed up in their fear? But Elle conceded it's often not the case that you can make a mistake and be convicted of a crime when there's nothing wrong with your moral code. You made a one-off error that the courts recognise. We said that scale should be extended right up that chain, and that was the case we were arguing for. It's just not true that someone who has previously made a mistake means they're otherwise there. The responsibility to vulnerable people within their workplace. You can never make people safe, Mr. Speaker. You can never remove their risk of being the victims of crime. And you shouldn't legitimise that fear and play into it by saying you need to be scared of past offenders. You need to watch out for criminals around every corner, because that is how people get paranoia and moral panic. You give that right to the states and the courts when you're an individual in society. You say they will be the ones that protect me from re-offence, they will be the ones that police. You do not have a right to be a vigilante and take that into your own justice when you live in a society where you gave up that right to the courts and the police system. Then we heard that you had to protect assets and reputations. We said you should be testing all of your employees for that, not using a poor correlation that is past offending, as they and we have been saying all down the bench. But it's a self-fulfilling calculation to say that past criminals will always be criminals. You cannot say that and not, like, there's no counterfactual in which you could examine that, because when people presume those things, they treat people like criminals, which makes them more likely to be criminals, Mr. Speaker. Lastly, on minorities. We heard that without this information, they'll be judged. We said they were going to be racist under both conceptualisation of the model. Madeline's material was why those people couldn't go to the lawsuit against them for discriminating and say, in actual fact, we were using their criminal record. And when over 10% of young African-American males are in prison, and another 40% have previously been to prison, that was a really easy way to be a racist and discriminate against black people if you could point to one minor offence on their criminal records. Then we heard that this is a poor message to send about unemployed people. You were the team that were happy to send messages that were accurate to people. We said it was an accurate message to say that unemployed people had a high correlation with crime. But in any case, there was no analysis about why this would be a tangible message, or that message from our policy would be communicated effectively to those people. So for all those reasons, because they have an obligation to protect their society and they have a unique ability to rehabilitate, they should not use this arbitrary and unworthwhile correlation.
Thank you very much for that speech. We now invite the negative speaker.
Mr. Speaker, I'm going to take the best possible case from the affirmative, because Lord knows they have. Let's assume that this individual committed a crime at 18 by having sex with a 14-year-old and is now applying for a job to be an accountant. What do we know about this individual? We know that at a period of time in their life, despite being bound by social norms, they thought their satisfaction was more important. What we know at that time is, despite the society's adjudication was that this girl was not in a position to consent to that sexual relationship, they demanded what they wanted. They went against what other people's expectations were. They were unreliable and untrue to those around them. Insofar as that's true, we think compared to someone who has not done those crimes, they are a relatively less worthy employee, insofar as Gemma said that integrity was an important characteristic when you're hiring someone. But let's not pretend that is the most likely characterization. Or that in that instance where it was a crime that was not significant or committed a long time ago, that wouldn't matter that much to an employee. This debate was about the right of employers not to be imposed on by the state to do their duty to defend other citizens from criminality, but to defend the citizens most close to that employer, i.e. their co-workers and their employees, from the risks of criminality. The first question I'm going to ask is this relevant? The second question I'm going to ask is, are jobs required for rehabilitation and reintegration? And finally, minorities, question mark. So, the first question about is this relevant? The first way that this is obviously relevant is where it's directly relevant. So when you have a thief manning a till, they won't talk about CEOs, but clearly there were many more ways in which that was true. And we think that concession that where it is relevant, obviously in a highly circular way, our model wouldn't apply. We thought that was a concession that a significant portion of criminals would not apply. But let's look at their irrelevant criminality that supposedly existed in this debate. We thought it was relevant for a number of reasons. Number one was protection. And Bissett said on this that what they had to show to you was that crime was incredibly likely to occur in the workplace. At Madeline, they said that the reason they were making an exemption for child sex abuse was because the risk was high there. So the question then for the negative was, how high did this risk have to be? And we said we didn't even have to clear an absolute barrier, only a relative barrier. So if you're faced with two employees and you're choosing between them, and one doesn't have a criminal record and one does, you are relatively exposing the employees in your workplace that you have a legal responsibility to a higher level of criminality. But even if that weren't true, even if you couldn't rely on the relative comparative in this debate, we think individuals who have committed rape, by the acknowledgement of recidivism that started at the beginning of Gemma's speech, are likely to commit rape again. And when we're looking at crimes that significant, female co-workers might feel that it was important for the person they've entrusted their living wage to take that into consideration when determining their employees versus a non-rapist in this debate. Then the next thing Bissett says is that crime only occurring in the workplace is one that matters. We think it's bad for your business if your employees are convicted of committing an act of rape on their own time. And we think that is incredibly damaging for your brand or image. We also just thought that necessarily when we look at most of the crimes that happen in this debate, like theft and like removal of property, that was relevant. Or like someone's propensity to turn to drugs, because that employee at the point they go back to drugs will be far less reliable than another employee. We thought they were all relevant considerations for protecting your interests as an employer. The next thing we'd say is integrity in general. If you've committed a crime, you've overridden social norms, you value your self-worth above other people, and ultimately, in those instances, you've violated people's trust in certain crimes, you've violated someone else's right in respect to what they want in other crimes. We think those instances are incredibly important. But in instances where this was least relevant, we thought it would also be least relevant to employers. But even in the marginal case that I explained in my introduction, integrity still mattered. So general was fine with employers asking the question, asking questions about moral integrity to all employees. We think the questions like, have you in the past had moral transgressions? How did that affect you? What important moral quandaries have you faced? Should include information about criminality. That should be suppressed, since it's the most powerful way that society judges someone's integrity and someone's past moral behaviour. So we thought you couldn't divorce those two things in the debate. The next thing they said, it was arbitrary for you to exclude children. No, it's not, because insofar as it's arbitrary that we don't send children to maximum security prisons for life. Like, yes, it's an arbitrary distinction, but it's based on the arbitrary age of 16, representing metaphorically where we think someone can consent, and below that we have different punishments. So we can have different punishments on this basis as well, unless they want to, by the same logic, try children as adults. So the next thing that they want to talk about in the debate was employees themselves, where they're making arbitrary decisions. The most ridiculous characterization came in Bissett's speech, when he said this is much like a self-inflicted disability. Mr. Speaker, is it more like a disability in this sense, or is it like an academic who, when they apply for another academic job, being forced to tell their employers that they've had past cases of plagiarism? Is it more like someone who's gone bankrupt, being forced under the law to tell future employees they went bankrupt when they're doing trading deals with them? This wasn't a disability, because these people were making choices, unlike the disabled. But even if we look at other forms of discrimination, like religion, where technically you're making a choice, we think these choices are fundamentally different. So their argument was, employer discomfort is what fueled racist and sexist employment decisions. But not all forms of discomfort are the same. The discomfort of meeting Gemma, being like, ooh, a woman, I don't want to work with her, is different and less rational than, ooh, a rapist, they are far more likely to commit rape than the average person. We think the conferral of information that an employer is making when they interact with the statement, I am a rapist, and the conferral of information when they interact with the statement, I am a woman, are fundamentally different, because in the case of no one feeling discovered in the first place, society feels that is far less rational, which is why, we don't punish people for being women. So, the next thing they said was that we could impose these obligations on these individuals because they are corporations. That's not how obligations work. The state doesn't just say, you are making money, and it would be most useful for us to coerce you, and the fact you're making profit means that we can, to take things from you. We thought that was outrageous in this debate. When these people pay tax, we don't force them to take on arbitrary obligations when they're not making arbitrary distinctions. So we said you couldn't necessarily discriminate against someone on arbitrary grounds, but where we prove that this is non-arbitrary, we don't think the state has a right to structure all decisions you make about capital just because that would be most convenient for the state when it was their responsibility to rehabilitate. Which brings me to this question. In the most recent speech, Bissett said, jobs are what keep you and I from reoffending. Well, Bissett doesn't have a job, so it's unclear why he's committing crimes left, right and centre. Because jobs aren't what keep you and I from reoffending. The disincentives of being sent back to prison is what keep you and I from reoffending. And that's what's going to keep these criminals from reoffending. We didn't have to give them pats on the back and make them feel better about themselves. We had prison sentences to disincentivize crime. But insofar as we did, we think we should teach these prisoners to be resilient. These ones wanted to create fiction that you hadn't committed crime in the past, or that people wouldn't judge you. That was ridiculous. We thought that we needed to be serious in helping them deal with the fact that all kinds of people, not just employers, are now going to judge you, and they need to be resilient to that, because otherwise they were more likely to commit crimes. What they said in this debate is that judges, we conceded that judges, that this was a consideration when judges could expunge records. What we were saying is that by their logic, the judges are good at doing this. If judges were good at determining where we should suppress records, where they haven't suppressed records under the status quo, judges have conferred that as a sentence. And because they were happy when people serve lifelong sentences in terms of their employment, like being a CEO, we thought that was fine, because judges could also do that in a general way by sending out responsibility to employers who just want to protect their capital by making non-arbitrary decisions. Let's look at finally at minorities. So there are two types of racism on both sides. But on our side, the racism we're privileging is protecting non-criminal black people as opposed to criminal black people. Like, you might use criminality as an excuse to hire a black person, but on their side, you might use presumed criminality as an excuse to hire a non-criminal black person. That's a far worse type of racism. They then said that on their side, you didn't prove any tangibly that we would send a message about poverty. You guys said you needed a job to feel dignity and self-respect. People who didn't commit jobs are far more likely to commit that crime. Bissett said that correlation exists. We were creating a distinction between those that responded to that correlation and those that didn't, which empowered more people to continue on not committing criminal activities throughout this debate. This wasn't an arbitrary decision about who self-inflicted a disability in this debate, Mr. Speaker. It was a relevant consideration to protect your property, to protect your workers, and protect your people from people that lacked integrity and moral discretion. We were so proud to achieve this.
Right, thank you, Speaker, for your speech. We now move to the reply portion of this debate, and my first reply from the executive team.
Mr. Speaker, the very first and quite quick question in this debate was whether or not a criminal record was an arbitrary and extrajudicial punishment imposed upon ex-criminals. The negative told you two things. Firstly, that it's not arbitrary because recidivism rates point to a higher risk of these people reoffending, and that is a rational consideration. But secondly, we told you that it wasn't extrajudicial. I explained in my speech that there are a number of factors such as age, suppression and the worth of a criminal record that meant that this was a judicially considered and a punishment that was at the discretion of the judiciary. Therefore, it was the imposition of a criminal record imposed by the judiciary. The next question then, given that this wasn't arbitrary or extrajudicial, became whether it was a worthwhile thing to have, which brought us to the question of whether or not criminality in the past was a relevant consideration to be considered by employers. And this was important to the debate, Mr. Speaker, because although the affirmative team tried to tell you that employers don't have a right to impose extrajudicial punishment, they didn't contest the right of an employer to consider factors that affected that employment. So let's look at why it did affect that employment. Firstly, we told you at a general level that past behaviour was a good indicator of future behaviour and that they were more likely to recommit an offence than other members of society. The affirmative team's response to this was to say they are not automatically going to reoffend. We told you that was true, but what we told you further was that it was okay for an employer to just value the risk of that reoffending, because the harms that would accrue to the employer were great if that risk did come to fruition. So what were those harms? We told you that the harms of reoffending of offences to the person would be detrimental to co-workers and consumers for two reasons. Firstly, that we should prioritise those stakeholders because they are already in a legal relationship with that employer. And secondly, because they have the right to feel safe at two levels. Firstly, that the employer is not going to hire someone who would be of risk to them. And secondly, that the employer will be able to be proactive in protecting them against people. Maddie's indignant outrage at an employer taking a sexual harassment complaint against a rapist more seriously than against someone else showed the gross disregard for the protection of co-workers and consumers that plagued the affirmative team's case. So let's look at, secondly, property crime. We told you that an employer has an interest in protecting their assets and the perception of the integrity of their company. The responses of the affirmative to both property crime and crimes against the person was to say two things. Firstly, again to reiterate that this wasn't an automatic thing that would happen. Again, we told you that it was still worthwhile an employer valuing that risk. But secondly, they told you, as their case whittled down, that where it was relevant to employment, they wouldn't allow that person to be employed in that workplace. That concession was important for two reasons. Firstly, because it acknowledged the general principle that we established in our case, that past behaviour is an important consideration in viewing future behaviour. But it was important, secondly, because it conceded that even though jobs were valuable, they shouldn't be open to everyone in today's debate. So that brought us to the final question of today's debate, which was whether rehabilitation was really the responsibility of employers. Because perhaps it was the case that criminality was a consideration for employers, but that they should overlook it in the interest of rehabilitation. The conception of rehabilitation on the negative was that it was the realm of the state, that the state should upskill criminals and give them the best opportunity to get a job, but not enforce employers to hire them. We told you there was no right to a job. I pointed to the examples of bankruptcy, Swain pointed to the example of academic plagiarism. We got no response on that. But we also told you that it wasn't a right because they had committed fault in today's debate, which was why it was different to disability. Jobs are obviously ideal for people in society, Mr. Speaker, but we told you there wasn't a right for that, and that employers didn't have a burden to hire people that weren't the best place for their workplace. That's why the negative team won this debate.
Thank you very much for the final speech of this debate, and I'm going to
in the same way that Swain wanted to differentiate between poor people and minorities who choose not to commit crime in spite of the significant correlation that exists between those two things. The affirmative team created the reason to avoid and not succumb to that correlation for previous criminals. We created the reason and the incentive to avoid that correlation. The negative team continued that correlation, exacerbated that correlation by feeding into the very stigma which causes reoffence. Let's ask three questions. First, is previous criminality relevant enough? And this was a competing conception in this debate, because whilst the negative told you that people who have previously offended are more likely to do so in the future and pointed to some kind of intrinsic disposition towards crime, what you had from the affirmative was a more realistic analysis, which said that the picture looks more like a catch-22, whereby people commit crime often as a result of circumstantial things. And because of the stigma, because of the lack of reintegration into society, they often are forced back down that same path. We told you this was a cyclical problem which could only be stopped and which the correlation could only be broken for in the event that we did something different than the status quo. But we also told you that the logic of the negative extended to some incredibly problematic outcomes. They told us at the end, as it got further, these people would basically never be employed because no matter how relevant the job was, no matter how relevant the risk was, there was something wrong with that person and their moral calculus, conceding that these people would never be able to access employment. But we also told you from the affirmative that often it wasn't relevant, and that's why they conceded that courts make judgments all the time about where it is and isn't relevant. We told you that courts could make those judgments here. But finally we told you that often it was used as a guise to discriminate in ways that were entirely irrelevant to someone's capacity to do the job, and this was a whole host of Madeline's material. But let's look at the second question, where even if there was a correlation between those two things, who should be empowered to make the choice about how significant that correlation was? We told you that in the instance that there was a risk of reoffence, that courts could and should judge that risk because they were more representative of society's interests and because there was one punishment and that was a principle we wanted to stand for. The negative told us, in contrast, that employers have a responsibility to their business, to their co-workers, to the reputation of that business and to the customers. We told you that that very responsibility which they analysed meant that that actor was entirely biased in the way they would treat that individual and so weren't the right actor for the state to empower to make that particular decision. The final question we want to address in this reply is what is actually best for society, of which employers and co-workers and customers are all a part. We told you rehabilitation for these criminals is the best outcome, and that's reliant upon not just the physical income of money and having a job, but the support network and the dignity and livelihood and the potential future that come along with that job. What we heard from the negative, in contrast, was that these people are unlikely to reoffend purely because the threat of going back to jail exists, where they had also pointed to the failure of that threat to actualise the rehabilitation in the first place. We told you often circumstances are what causes these things. We say that you remove the instance and the motivations for these people to avoid and rise above those circumstances. We were the ones that provided you the rehabilitation in this debate, which was ultimately better for every actor, and that was the reason why the state could and should force employers not to discriminate in a whole host of ways that they do in every other circumstance of discrimination which the affirmative team pointed you to. But finally, it's critical to remember, and this was all of our material in this debate, that there was no utility of acting on a correlation when that correlation was self-fulfilling, when it continued to exacerbate the very correlation that may have existed in the first place. And that's why the affirmative team won this debate.
Thank you very much, everybody.